Welcome to Case by Case. This is a podcast brought to you by Callum Chain and Luke Zadkovich from ZFZ. Welcome, everyone. We're pleased to have you on for another episode. How are you today, Callum?
I'm good. It's a big moment. It's our first decision involving males, Lord Justice males of the year.
It is a big moment, and he's on the dissenting side in this decision.
Not everyone's such a fan as us, it seems.
I know. And Lord Justice Noogie was really in the middle on this one, wasn't he? He was going back and forth between Lord Justice Popplewell and Lord Justice Males, and then ultimately went in favour of Popplewell.
Without the benefit of the experience of this bench, I was still, for my part, going back and forward as I read it. Up until the last second, actually, I thought this was one where Popplewell, Lord Justice Popplewell, had the right decision, and I thought it makes complete sense, perfect sense. And then I was going back to the key clauses and reading the judgment of Lord Justice Males, and I think it's just right. This is a really interesting case. It is so on the wire. And it's one of these contractual construction cases where you can read the contract in really either way.
Yeah, absolutely. And I think the opening paragraph of Lord Justice Males' dissenting decision in paragraph 64 says it all. I agree with much of Lord Justice Popplewell's judgment, including his approach to the issue of construction arising in this case. But with respect and some hesitation, I have reached a different conclusion on the particular wording of exclusion 9, which we're going to get into in some detail. But the admission of some hesitation in arriving at his judgment here, I thought said it all about how much of a line ball this one is. So look, we're talking about insurance law. We're looking at an insurance law policy and construing the terms of that policy to work out what they mean, whether the insured is covered or not for the loss, and we'll give a little bit of explanation about that in a moment. Before we do, just for those who love citations and knowing exactly what case we're talking about, this is the English Court of Appeal decision in Brian Leighton Garages Limited and Allianz Insurance Plc. Another recent decision handed down on the 11th of January 2023. As we've said, we had three Lord Justices sitting on this one, Males, Popplewell and Noogie, and it is an appeal from a decision of Ms. Claire Ambrose, sitting as a Deputy High Court Judge on the London Circuit Commercial Court. Interesting decision. Where should we start? Should we just give the facts? The facts are important, but I don't think it's a hugely factual intensive case. The facts were essentially assumed for the purposes of this matter. But let's go through them, hey?
Obviously, Allianz are the insurer, and Brian Leighton Garages Limited are the assured, and the insurance policy that they had was an all risks policy for their garage, and this was basically a petrol station where people can come in and fill up. And what had happened at some point during the policy period was that a sharp stone had managed to become embedded in a pipe, causing a leak. And the leak then caused a kind of contamination or pollution event around the forecourt that was risky, or there was obviously the risk is obvious. There was potential for a massive fire hazard, and ultimately the cost of the repair was too much. The appellant claimant Brian Leighton Garages decided not to make the repairs. Eventually sold the business and claimed under the insurance.
Yep. And the insurance company declined liability. They said that this type of damage was caused by pollution and contamination, and that was an excluded risk under the policy. There's some quite nuance around the language which we're going to describe, but in at its high level, this was a decision by the insurance company to decline liability as it was not a covered risk in their view. So, yeah, look, big consequences, hey, for this garage owner. Shut down entirely, couldn't afford to do the repairs, and I imagine it would have required significant work to try and deal with that contamination and pollution.
Yeah, and the type of contamination and pollution is not a massive shock, right? It wasn't like there was a contaminant or a pollutant from a passing vehicle that flips over and pours a bunch of oil all over the forecourt. This is a petrol station, and they have a leak of petrol. This is surely something which is in the contemplation, and I think as kind of any person would, when I'm reading through this judgment, as I'm first going through it, I'm thinking, hang on a minute, surely these guys are going to be getting their payout, and ultimately they do. But when you really dig into the questions around the way that causation is treated in insurance policies and the way the specific wording of these exclusions are included here, I'm not sure that it's right.
Yeah, I know. And I had the same kind of back and forth as I was reading it as well. Having done a lot of insurance work over the years and looked at coverage or indemnity issues as they're described in different jurisdictions around the world, they're more complicated than they look. And I know that it came through a few times here that you've got to look at an insurance policy as an objective bystander would, in the shoes of an insured. And it's not to the level of being a pedantic lawyer as it's been described in the ARC case, but as Males says in his decision, it still does require the parties to look at it from some level of sophistication. They can get brokers, they can understand what these terms mean. There are terms of art that have developed in these insurance policies. They need to be understood with respect to the prevailing law. And it really throws up this case. How does causation work in the context of an insurance policy? And I think that's useful to go over and look at. But then how have the parties dealt with causation? So you might have a general principle that that refers to the proximate cause of something for the purposes of whether an event falls within cover or not. But then in the policy itself, the parties can displace that general understanding of proximate cause and bring in a different type of test in the insurance policy for causation.
Yeah, and I think it's worth kind of going a little bit further on the facts here. The parties, and it seemed actually as though at the appeal stage in front of the Court of Appeal, the issues became really narrow during the oral argument, and it seemed as though both parties kind of gave a little bit, or admitted or conceded that some of their arguments really weren't going to run. So you have a very, very narrow decision on here, which is helpful when you're reading through it. It's very targeted what everyone's talking about. But essentially, the damage that was done to the forecourt was a polluting or contaminating damage, and it was in part. This is all kind of agreed. It was at least in part caused by pollution or contamination, but the proximate cause was this sharp rock that got lodged in the pipe. And everyone seemed to be on board with that, at least in oral argument. Everyone was on board that the proximate cause was this little rock that got caught in a small sharp rock, got caught in a pipe and created this leak. And everyone also says the damage that was caused was also caused or was then caused by the polluting or contaminating effects of the leak. And it was even agreed as a kind of legal principle, and we can talk about this legal principle in a little bit of detail, that under an insurance policy, ordinarily, you're looking at proximate cause and proximate cause only. Not always, but ordinarily, what you're looking for is proximate cause. And the question is then whether the parties have done something special in this contract which suggests that what they're thinking of for the purposes of the when they're defining cover, I don't want to say the exclusion for pollution and contamination damage, because technically that's not right, and that was something that all the Lord Justices were agreed on. But when they're defining the scope of cover and saying that pollution damage and contamination damage fall outside the scope of cover, were they saying that is only relevant to damage where the proximate cause is pollution or contamination damage, or were they saying this is relevant to any damage which is caused by in any whether it's the proximate cause or a non-proximate cause? If it's caused by pollution and contamination, then is the reduction in the scope of cover big enough to also include those things that are caused by pollution and contamination but not proximately caused by contamination and pollution? Yeah,
exactly. And it's a tricky one to get your head around, I think, if you don't do a lot of this kind of work, because we're talking about like a chain of causes, okay? So you've got the initial puncture of the pipe with the sharp stone. You've then got the leak. You've then got this leak of fuel, which then pollutes or contaminates the surrounding forecourt. The problem with the forecourt and what makes it unusable and what ultimately shuts down the business is the pollution of the forecourt, right? And it all can be traced back to the initial puncture of the pipe. But you can see how there are layers of causes, or there's a multiplicity of causes in this. Approximate cause being what triggers the whole thing and starts the whole thing. But there are multiple kind of causes that kind of stack up on each other along the way. An insurance policy can say, okay, we're looking at, for the purposes of cover, what is the proximate cause? What kicks the whole thing off? What's the most efficient or effective cause in this whole chain? Or it can say, well, if any of these causes, so if there's any type of pollution in a process sense is involved in this chain of causation, then that is covered or not covered, depending on what the parties have done in the insurance policy. So it's really interesting, and it's where you've got to look at the policy to see, have the parties deliberately displaced the general principle that you're going to be looking for a proximate cause for the purposes of covering an insurance policy.
And while we're on proximate causes, this was, I thought, a very interesting part of the judgment. And this was part of Lord Justice Popplewell's judgment. There are circumstances which are not particularly unusual. It's not the majority of cases, but it's not an exceptionally rare minority where you have concurrent proximate causes. And the one that was interesting was the fact that every single individual COVID infection in the United Kingdom was a concurrent proximate cause for the lockdowns that happened in 2020.
Yeah, of course, yeah. An interesting one. So, okay, so look, some of the principles, and we've touched on this. I think Males's decision, actually, Lord Justice Males's decision, is quite helpful in this sense, because he has a neat recap of the principles that were set out in full in Mr. Justice Popplewell's or Lord Justice Popplewell's decision. And just to skip through some of those, as we've kind of touched on a little bit already, but the policy is to be interpreted objectively as it would be reasonably understood by an ordinary policy holder, and that one of the principles that we're dealing with is that an insurer is only liable for loss proximately caused by a peril covered by the policy. However, that principle is based on presumed intention of the contracting parties and can be subject to a contrary agreement. Here, as we've said, it was essentially assumed for the purposes of the appeal that the proximate or efficient cause of the damage in this case was the penetration of the fuel pipe by that sharp object, and that what we're dealing with and what we're looking at is the words of exclusion 9, the exclusion of damage caused by pollution or contamination, and whether it only refers to proximate cause of the damage, and if so, the appeal must be allowed, and if not, it must be dismissed. So perhaps, Callum, if we go to the wording of exclusion 9, and it's on a few reads of the actual wording that I ultimately sided with Lord Justice Males and indeed Ms. Ambrose on this.
I think for me it was on a few reads of exclusion 9 where I started to understand what Lord Justice Males was saying, and then a few reads after that where I thought, actually, he's right. It took me a while to wrap my head around this one, so I'll try and explain it in a way that hopefully our listeners won't have to suffer the same fate as I did. So you have these exclusions, and they're called exclusions to cover, but they're not strictly exclusions. They, in the sense of that, there's not a contra preferentum argument against them. This is it's simply setting out the cover. So they're covered apart from these things. And one of the things that they are not covered for is pollution or contamination. And the exclusion reads, damage caused by pollution or contamination, but we, as in Allianz, will pay for damage to the property insured, not otherwise excluded, caused by pollution or contamination, which itself results from a specified event, or any specified event which itself results from pollution or contamination. So you have this kind of multiple tiers to this. You have the general cover, and then you have the exclusion from cover around things caused by pollution and contamination. And then you have the kind of exclusion to the exclusion, if you like, or as they called it in the judgment, the right back.
Right back, yeah.
Which is the pollution or contamination which is caused by one of these specified events. And the specified events were things like fire, earthquake, lightning. They weren't relevant here, but they do inform the way that you read this clause. And remember that we're reading this clause only to try and establish whether the words caused by, so under exclusion 9, the exclusions of this policy, the policy says that it does not cover damage caused by pollution or contamination. And what we're trying to look at here is whether those words caused by are talking about proximate cause or they're talking about any cause.
Yeah, exactly. So as you say, Callum, you've got this language, the policy does not cover damage caused by pollution or contamination. So the question and what we're looking at is whether caused by means proximately caused by, or it means not necessarily proximately caused by. And those are the opening words of this exclusion. And then it gets more complicated because you then have this further exclusion with a right back provision, which then writes in that certain events will be covered. And so you've also got a duplication. You've got caused by appearing twice in this provision. And look, when I've read it a few times, and I'm totally with you, this wasn't an easy clause to get your head around. It's just like set out in a pretty, I don't know, it's complicated way. It's not an easy clause to read. The way it's structured here,
I think the way that it makes the most sense to try and understand what the arguments were, or what the ultimately what the dissenting judgment came to. I mean, in a way, the judgment that prevailed here was that in the ordinary way for insurance contracts, damage caused by pollution or contamination means damage proximately caused by pollution or contamination, and therefore the exclusion only applies where the proximate cause is pollution or contamination. In this case, the proximate cause was the small spiky rock, and therefore the exclusion doesn't apply, so the policy covers the loss. Whereas if you read in, and this is how you kind of get to Lord Justice Males' thinking, if you read in proximate cause, so you say that the exclusion applies to damage proximately caused by pollution or contamination, except where the proximate cause, except where there's another cause, which is pollution or contamination from a specified event. And then the question is, well, what's the proximate cause in a situation where, well, if the exclusion only works where the proximate cause is pollution or contamination, then how can that proximate cause itself be caused by one of the specified events? So how can the proximate cause in clause 9 itself be caused by an earthquake? Because in that situation, surely the earthquake is the proximate cause. So the way that clause 9 is drafted, it has to be broader than simply saying the proximate cause.
Exactly. Like if this clause ended where it says damage caused by pollution or contamination, full stop, it'd be an easy case.
Yeah.
There was no contention about this on the basis of principles under insurance law and construing these policies. That would be taken to mean damage proximately caused by pollution. And so when you then think about that in a factual sense, that would mean that it's pollution or contamination that needs to be the proximate cause. It's not like we've got here where there's something further up the chain that's kicked the whole thing off. It's the pollution that is the proximate cause, and that would have been an easy decision. It would have been clear, and we'd know where we stand. But what we then have is we have all this other language and these right back provisions. And as you say, Callum, what's the effect of those subsequent words? And when you try and put them together with the initial words, it doesn't really make sense if you write in proximately caused to the initial part. And you've got to make sense of it. It has to read together. This is all one sentence. It's not even separate sentences. It's all part of it. So when you then go on to deal with pollution or contamination, which itself results from a specified event, and a specified event is likely to be the proximate cause, it doesn't sit right. It doesn't sit well to then be reading in proximately caused by earlier on in the provision.
I think that's where ultimately, in my view, I think that Lord Justice Mails's analysis is probably the right one legally, but it's still it's odd to me that a part of, so again, you have the exclusion clause and then you have what's called the right back language, and the right back language narrows the exclusion effectively, which is normally to the benefit of the assured. But you have the situation where the effect of that right back language, which would normally be to the benefit of the assured, actually increases the scope of the exclusion quite significantly in a way which I find slightly bizarre.
We might not be persuaded by the leading decision here and the majority view. But what was the main reason for why they decided the way that they did?
Yeah. So, and I think a good place to start on this one is the short judgment of Lord Justice Nugi, because that's you have Popplewell, Lord Justice Popplewell gives the lead judgment, and then Lord Justice Mails gives the dissent, and then it's Lord Justice Nugi who is kind of between the two, and you can really see that it's a toss up. The part of this judgment that I thought was very interesting is paragraph 59, because this deals specifically with the issue that we've been talking about there, this construction issue. And Lord Justice Nugi says, I think it is possible that the resulting spill of sewage into the petrol station, and this is in the context of an earthquake causing a spill, causing a contamination. I think it is possible that the resulting spill of sewage into the petrol station could also be regarded as a proximate cause of the resulting polluting damage, or at any rate that this might be thought to be an argument that the insurer might otherwise seek to deploy and hence deny cover under the Wayne Tank principle, which is a case which is referred to in the judgment. So the idea, the comment there goes back to what we said earlier, where you can have these two concurrent proximate causes, and in the Lord Justice's judgment, in that situation where you have the earthquake, just the fact that the earthquake itself would happen, I guess, sooner in time than the subsequent polluting of the insured property wouldn't necessarily have the effect of meaning that the exclusion at clause 9 can only sensibly be read with a broad lens. And actually the normal principle, which the insurer has to argue away from, right? The normal principle is proximate cause is what you're looking at. So the insurer has to persuade the court that they should depart from that normal principle here. And the other two Lord Justices in the majority, I think, were effectively saying, well, we're not convinced that this is the right thing to do. We need more to move away from this general principle. Just
kind of unpacking that a little bit more, the factual scenario, hypothetical that's being discussed here, and Lord Justice Noogie explains that it's helpful sometimes to look at hypotheticals to bear out the legal principle, and the example he uses here is that suppose there was an earthquake and the earthquake damaged a sewage pipe that was in the vicinity of the earthquake, and that damaged pipe, the sewage from the pipe, then contaminated the petrol station. And Lord Justice Males is looking at this by saying that in that case, the earthquake would be the proximate cause, and that there is then quite limited scope to the right back provisions.
Yeah, because they never apply. Because if the earthquake is the proximate cause, then the kind of effect under the exclusion clause, if you get that far, would be that the polluting damage is ignored. But you don't get that far, because if the earthquake is the proximate cause, then the exclusion clause around pollution or contamination, if read in the way the majority read it, doesn't apply. Yeah. And if that doesn't apply, then how are the right back provisions supposed to be given effect to? And it's that old principle that you see sometimes of, if you've written it down in a contract, we'll try and make sure it has some meaning.
He agrees that the earthquake would be at least a proximate cause, but that he thinks it's also possible that the spill of sewage into the petrol station could be a proximate cause. And if you look at it that way, and you look at a scenario where you could have two proximate causes, even though it's in this kind of chain of events, then you can start to make sense of the construction of A in exclusion 9, and you can give it some meaning. Yeah, it's the counterpoint to what Lord Justice Males says. But I don't know how realistic is that in those kinds of scenarios where you've got maybe it's it's not a damaged sewage pipe, but it's a poorly maintained sewage pipe that that had it been well maintained, maybe the earthquake would not have led to it breaking. Yeah. But there was the earthquake, but there was a poorly maintained sewage pipe that then broke. You needed the earthquake. Yeah. It wouldn't have leaked without it. But you also needed the sewage pipe to be poorly maintained, and it then caused it. So in that scenario, you can actually say, okay, yeah, two proximate causes. Without either of them happening, the event wouldn't have taken place.
I see what you mean. But if it was just an earthquake, which then causes an otherwise entirely healthy system to break, then it really feels like the earthquake is the proximate cause. Yeah. And do you so this is now a case which has gone to the High Court, and it's been dealt with by the High Court. It's then gone to the Court of Appeal, between four extremely preeminent judges, or Ms. Claire Ambrose sitting as deputy judge, and the three Lord Justices on the Court of Appeal. You've got 2 and 2. One, for either side. It's right down the middle, and
2 and 2, and the second of the two going for allowing the appeal was on the fence. Yeah, It was a kind of just a leaning one side. It wasn't I'm jumping into the camp wholeheartedly.
Yeah. I wonder if there is a subtext to this, which is that in a situation where it's so finely balanced, there is just a general principle that again, stepping kind of back a little bit, these guys took out insurance cover for a petrol station. There was a leak caused by a little stone getting caught in a pipe somewhere and breaking the pipe. What they thought they were insuring is surely covered in this situation, and the decision of the Court of Appeal does go into a lot of detail around the way that you should be interpreting these kind of contracts of insurance, and I think that did weigh on the minds of Lord Justice Popplewell and Lord Justice McGee. But I wonder if it's for that reason the right decision.
Well, yeah, look, that kind of strays into policy considerations. And so I'm not sure how much that bears on the question, but I hear you, Callum. I think, if I'm the garage owner here, I'm feeling like I've been stiffed by the insurers, right? And from an insurance perspective, you've also got to look at it from both sides, right? From an insurance perspective, this is probably language that appears in many, many, many insurance policies. And the decision here that goes against the insurance company could have significant ramifications across the portfolio of policies they've got here. That's one reason why I suspect this goes up further, and we may well be talking about this case again at a higher level, because it is the type of wording that I can see having a knock-on effect in other policies. And from an insurer's perspective, we have insurer clients, we have business clients, we've got to be able to look at these things from different perspectives. They set out to insure certain risks, and their underwriting is performed on the basis of what is and is not covered. And there's very sophisticated actuarial processes that go into working out how much they should be charging for policies, what's the risk exposure, what are the reserves they should be covering, all of the rest of it. And that's based on the language that appears in their policies and what they think is and is not covered. And if you are insuring pollution or contamination as a primary proximate cause, that is different to whether you're insuring it as a flow-on, from something else that's a proximate cause.
So shall we wrap this one up with the 2-minute summary?
Yeah, let's do it. So basically, this decision was all about construing an insurance policy and whether the exclusion relating to pollution and contamination was restricted to only causes of approximate nature, so where contamination and pollution is the proximate cause of the damage, or whether the terms of the particular clause dealing with pollution and contamination was broader, and it had displaced the general principle that it is a proximate cause that you look for and could include causes of a non-proximate nature. And the majority decision went the way of the garage owner and against the insurance company, and overturned the first instance decision. All
I would add to that is the head note for those who are listening just to the summary, which is Brian Leighton Garages Limited and Allianz Insurance Plc. And one other point that I thought was very interesting from this one is the construction question. And when you're looking at this kind of contract of insurance, then particularly in this case, you're looking at the commercial context of a small, medium-sized enterprise reading in a insurance contract, not looking into the detailed minutiae of the contract, but just with a sound understanding of insurance principles.
Very good. All right. Well, thank you everyone for listening in. We hope you've enjoyed getting into some insurance law today. This is the type of decision that can have significant ramifications in all sorts of insurance, and understanding how causation works in an insurance policy is quite important. So thanks for listening in. We hope you've enjoyed it. Good to catch up as always, Callum. Until next time, take care, everyone.